If we're going to have a federal anti-corruption commission, despite the fact that there's no evidence of serious systemic corruption, as opposed to perhaps pork barrelling or incompetence in Canberra, let's avoid the mistakes of state anti-corruption bodies, like the Victorian one that constantly makes findings against the Andrews government, but as yet not one MP or senior public servant has faced any significant consequences. Or the New South Wales one, the kangaroo court that routinely destroys people's careers on the basis of a rumour or trivia. I mean, Premier O'Farrell lost his job over a bottle of wine, and Premier Berejiklian over a dodgy boyfriend. Compare that with what happens, as I said, in Victoria. Whatever happens with a federal watchdog in Canberra, they must get the model right. Otherwise, the real danger in these anti-corruption bodies is that they can be weaponised against political opponents who are targeted on the basis of self-serving smears and partisan tittle-tattle rather than any real ethical failure, let alone criminality. That's why the latest concern about who can authorise anti-corruption commission phone taps or access to encrypted messages and emails is just so important. As things stand in the government's draft legislation, this can be a warrant from a judge or, this is the critical point, from a nominated member of the Administrative Appeals Tribunal. Now, the government says that this provision mirrors that for other integrity bodies, including the Australian Federal Police. Sure, but the AFP is not normally investigating alleged wrongdoing by ministers, spy chiefs and senior public servants. That's why using the AAT to authorise warrants, who are often people with political connections, doesn't encourage confidence that the process will be fair. Now, don't get me wrong, there are lots and lots of former MPs and staffers on both sides of politics who are well qualified to judge possible AAT cases. For 5 years, for instance, the president of the AAT was a former Labor minister who was also a well-qualified lawyer, Duncan Kerr. The issue here is not competence or even partiality, it's perceptions of fairness, or otherwise, in an area that's already widely perceived to be more about politics and payback than justice. When in opposition, Attorney General Mark Dreyfus was always adamant that investigations into terror suspects had to be authorised by an actual judge. Well, if a judge was needed in order to be fair to terror suspects, you'd think that MPs and officials against who allegations have been made deserve at least the same respect. It's much more important to get this bill right and this watchdog right than to rush it through.